Professor Daphne Tarras, Dean of the Edwards School of Business.
By the time you're watching this, former Dean.
Oh, thank you very much for contributing again with your co-author Scott Woolsworth to the 6th edition of the book. And tell us about the importance of the legal rights that are afforded to collective bargaining in Canada.
We had a very dramatic change between the last edition and this edition of the book. In the past, labor rights were statutory rights. They were rights that are found in labor acts and employment standards acts and human rights codes and so on. And what's happened is there's been a Supreme Court case that made collective bargaining a constitutional right for the first time. And this is a right under freedom of association. So freedom of association includes the right to collective bargaining. We don't know what's going to happen with it. It's an extremely important decision symbolically.
So why do these rights really matter?
First of all, it's in a democratic society, the right to collective bargaining, the fact that it's been made a constitutional right matters very much symbolically. It's the first time Canada affirmed that the group has a similar right to individuals. But we have absolutely no idea whether it will matter in Canada. And in fact, by the time people are listening to this, I would love to see if there's before there's a constitutional right and after, did it make a difference in organizing? Did it make a difference in union density? Are there different forms of employee representation as a result of opening this door? So the unions are ecstatic that this symbolic right was given to them. I don't want to see energies that are better spent at the workplace or lobbying for other things diverted into constant legal battles, and that's what I'm afraid of.
America, the United States, just south of the border, seems to adopt a rather different approach to employment relations from Canada. Now, why is it that Canada and the United States differ so much in the way they approach these matters?
I've been tormented by this question as a scholar since the start of my career. Is it a difference in values? But a lot of the survey literature shows not much. People want unions at about the same frequency and for the same reasons in both countries. It's got to be something different about the statutory regime. It's got to be different about the United States has one large system. Canada is divided into many different jurisdictions. So perhaps that's it. But it doesn't explain why all the jurisdictions have taken the same approach. So there is a Canadian approach. It can be found in our Constitution, which has a twofold test. I'm giving you always legal answers, but it's symbolic. We say that everybody has the right to something, unless a limitation on that right could be demonstrably justified in a free and democratic society. We say that's a twofold test. So we're very pragmatic in Canada. We have a more pragmatic approach. And in the United States, it's an absolute right. You have the right to bear arms. It's an absolute right. So I think this twofold test, and the history of Canada shows a profound interest in balancing individual rights and collective rights. And that is very strong in Canada.
Are there any other aspects of the future of employment relations in Canada that you might wish to briefly highlight, Daphne?
I'm watching a few different things unfold. One of the most interesting ones likely is going to be family status. A lot of countries have duty to accommodate on the basis of disability and disability rights. And a lot of countries protect sexual preferences, a lot of countries protect or sexual orientation, a lot of countries protect human rights. We're one of many countries that protects family status. Are you married? Are you unmarried? Do you have children? Do you not have children? One of the most interesting things that's developing in Canada is whether difficult family circumstances are what we mean by family status discrimination. So somebody who has disabled children, who must be home may not be able to change shift schedules. Someone who has elder care may be tremendously disadvantaged by not being able to take time off work to take a mother for chemotherapy. So what is the bright line? It's not any longer married, single, with or without children. It's how difficult are your circumstances, and is there any way the reasonable employer can accommodate? And I sure would be watching that one.
Very interesting. Thank you very much, Daphne.
Thank you.